The court finds that expert testimony is not needed for the jury to determine whether or not the investigation was compromised by any failure to follow procedures or pursue other suspects. Oh, but it's necessary for the Commonwealth to call the weather guy to testify to the hardness of the ground and how snowy it was that night. Okay, Bev, let's get into it. Hello, and welcome back, roommates, to Alexasrewm, where we are not lawyers, we are not medical professionals, and we are not law enforcement. We are just people. People who have opinions about all things going on in the true crime community, including this breaking news on one of Beverly Cannola Oil's latest rulings on the former FBI agent who the defense was looking to call to testify to the protocols and procedures or lack thereof that were followed during this investigation, in which many of the officers who participated in said investigation have also since fallen under internal affairs investigation, including the lead investigator, Chip Proctor.
I gently disagree with Mr. Brennan. He indicates that we want to use an expert to bolster our argument. There's another word for that, or another phrase for that. It's called presenting a defense for someone charged with murder. He indicates, well, what are we going to do? This guy's going to get up there and testify. What am I supposed to do? Call a bunch of other Canton PD officers to talk about how great their investigative techniques were? Yeah, there's another word for that. It's called rebuttal. That's what you're supposed to do. And then he says, well,
you wouldn't be objecting if they called somebody in rebuttal to reinforce a great investigation?
Oh, no. Mr. Brennan said, what if I called a Massachusetts state police officer to say that this was the best investigation ever? I have two words. Do it.
And I think AJJ summed it up best. Yeah, just do it. Do it. Do it, do it, do it now. And I'm not going to finish the rest of that lyric, but if you know, you know what song I'm talking about. I would love for somebody to create a video compilation of that to that particular song. But anyways, I digress. Why not just call your own rebuttal witness? Isn't this the whole point of having a right to a fair trial, is to put together a case to support your defense by calling experts? Why not have the Commonwealth just call another MSP trooper, right? And talk about how, flawless the investigation was and how it wasn't compromised anyways, despite X, Y, and Z conflicts of interest. This is just my opinion. They don't want the jurors to hear how a proper investigation is supposed to be conducted, what procedures and protocols. I mean, that would obviously benefit said jurors, especially if you're going to have the weather guy testify to how flippin' snowy it was that night and how that's allegedly relevant to injuries that John O'Keefe sustained on his face due to the hardness of the ground. It makes absolutely no sense to me that you would allow one expert to come in and testify to something that they're not even qualified to testify to, whereas this guy who's clearly overly qualified, I mean, she didn't even bother to have him come in for a Daubert Lanigan hearing, as opposed to Dr. Marie Slay the Day Russell. So if you don't believe that Bev is playing the biased game, perhaps these recent rulings are starting to change your mind. So this is just in from the Boston Globe. Former FBI agent cannot testify in Karen Reed's defense as Cannola Oil rules. A retired FBI agent, so Michael Easter, will not be allowed to testify on the shortcomings of the police investigation in the Karen Reed case during her retrial, which is slated to begin tomorrow, mañana, with jury selection records show. In a ruling today, Judge Beverly Cannola Oil approved a motion from prosecutors to exclude the testimony of Michael Easter, the retired FBI agent. Cannola wrote that Easter's written report, which has been sealed from the public's viewing, indicates he would testify that the investigation in this case was not reliable due to the lack of secured crime scene, absence of a detailed crime scene log or evidence chain of custody, the failure to separate witnesses, and the premature categorization of people as witnesses and potentially biased based on the failure to investigate other suspects and obtain their cell phone records. And I just want to bring up again Chip Proctor's internal affairs investigation report, which recently came to a conclusion, and he has since been fired, which they are allowed to talk about in this upcoming retrial, I believe. Whether or not they're going to be able to bring up the other internal affairs investigations, I have no idea. Chip Proctor, through his actions on various dates between January 29th and August 17th, 2022, did fail to conform to the work standards established for the member's rank, title, or position, and or did fail to take appropriate action on the occasion of a crime, disorder, and or other condition deserving state police attention. This occurred when Chip, while assigned as the lead investigator in a homicide investigation, through his unprofessional and inappropriate conduct, created an image that he was biased in his dealings with a homicide suspect, meaning he didn't have any other suspects, right? Because he just decided within less than 24 hours that Karen Reed was the culprit. She was the one with the candlestick in the living room, right? And or brought otherwise himself and the Massachusetts State Police into disrepute. Chip Proctor on July 19, 2022 did consume alcohol while on duty. So, I mean, imagine bringing that up to Michael Easter and being like, in any way, state or form, would it be, quote, appropriate for you to, kick back and throw back a couple of cold ones with your partner while on duty? Probably not. And just to call that out directly in court, how powerful would that be? Equally as powerful as the effect that those disgusting text messages had on the previous deliberating jury. I mean, we all agreed that was disgusting, uncalled for, inappropriate, but still, the argument from the Commonwealth was, well, that had no effect on the investigation itself. You're going to get the weather guy talking about how snowy it was that night, the hardness of the ground, then it would be nice for the jurors to know, okay, well, in that situation, if it really was the blizzard of the season, right? What is the best way to secure a crime scene if you're the Canton Police Department, right? And maybe you don't have as many resources available to you. Although we know you do, Helena, because you're asking for money every quarter for fancy mobile firearm ranges that you can rent out to other law enforcement. It's just really grinded my gears, honestly. Jurors are perfectly qualified, Beverly Cannola Oil says, to evaluate the adequacy of the probe without assistance from an expert witness. Well, if that's the case, then I guess anybody can testify to being an expert of dog bites, right? Without methodology. I can only think what Bobby Alessi was thinking as he was reading this ruling. But at this point, I mean, are we really surprised, folks? No, this is just how it goes in the land of Nod, in the land of canola oil. God, I feel like I'm gonna need like an epidural. Easter's proposed testimony concerns basic aspects of a police investigation. You should know this if you watch CSI, folks, which are within the common knowledge of a layperson. Through zealous cross-examination of police witnesses, the defendant can cast doubt on the reliability of the investigation by demonstrating how it differed from standard practices and procedure. But how do you do that if you don't have somebody who is an expert in standard practices and procedures and can raise the issue of potential bias by police action, as we such just laid out via the Internal Affairs Trial Board report on Chip Proctor's firing? But I digress. Or an action as counsel did effectively during the first trial. So are you agreeing that this was in fact an ineffective investigation? And then this goes on to talk about some of the other rulings. There was a ruling today about third-party culprit, which I do want to get into, but I'm not going to do that in this video because this video is already loaded with ton. Somebody shared this on the Twitter X's. Adam Scott on the Twitter X's sharing this general order of evidence collection and preservation as of May 25th, 2023. I don't know if that's like the last time this was updated. I feel like I went over this at some point in a different video of mine. Very possible, but Let's take a look at this. What does it say? What does it say? Policy. The department shall ensure that evidence is properly recognized, documented, collected, packaged, and stored. Already within that first sentence, you can fill in all of the holes of all of the things that weren't properly recognized, documented, collected, packaged, because they're still making up reports now, right? And logs from years and years and years ago. I don't think laying out John O'Keefe's wet clothes, did they collect that in a Stop and Shop bag as well too from the hospital, and then laid his clothes out to dry on meat packing paper for a few days after? I don't think that would be considered packaged, stored, and collected properly. But anyways, and shall ensure that a documented chain of custody is established for evidence recovered at every crime scene. So again, we have multiple crime scenes in this case, right, folks? First, it's 34 Fairview, and then it's the Sallyport. So I want to know, where are the logs for that? Where's the chain of custody for both those crime scenes? Training shall be required for employees in the proper collection methods of evidence related to their assignment. I would love AJJ to go like ham, like really leaning into this aspect of it, because now they don't have the expert to testify to this unless they're going to call him for whatever other reason. I don't see what the point of calling Michael Easter would be at this point. Or potentially having I guess like another officer testify to protocols and procedures, or maybe just cross-examine it on it. It's going to make the argument a little bit weaker. It's still strong. It's still obvious that there are many holes in this investigation, but it would definitely be a stronger argument to actually hear what they were supposed to do as opposed to what they were not. Now, whether or not they're going to be able to bring up some of the other cases tied to this investigation, I don't know, because in the Ingolf Turk case, which I have not been following, Melanie Little's been streaming that, so definitely go check it out. I'm just like on information overload, so it's really hard for me to pivot from case to case to case at once. But I believe Fanning was attached to that case. I think Chip was also attached to that case. So I would love to hear, if it's possible, if the door is open, for them to talk about, well, what kind of procedures and protocols did you follow in that case? There was an instruction that was given by the judge in that case as well, too, that instructed the jurors that, hey, you can't talk about the Karen Reed case either, because there's overlap here. So I am curious if Bev is going to give a similar instruction for the jurors in this case and say, hey, there are other ongoing cases happening right now that have to do with some of the same familiar faces in this case that you're going to meet very soon. So don't talk about those cases either. I don't know. All evidence that comes into the possession of a member shall be entered into the evidence control function prior to the end of the member's shift, unless exigent documented circumstances prevent the return or entering of said evidence, like, this program overwrites itself every 30 days, right? That's something that I'm sure we're going to hear more of. In the event of an exigent documented circumstance, the evidence shall be entered in at the next most practical time. So not like years later, folks, like next shift probably, right? That's probably what they meant there. Such delay in the steps taken to safeguard the evidence in the intervening time shall be documented in the incident investigative report. So why are you documenting this now as opposed to immediately? A descriptive inventory of the evidence shall be made verbally to the trooper duty officer, who shall then document it in the daily administrative journal. So they did talk about this, the journals too, when Proctor testified. I do loosely recall that. The troop duty officer shall be approving the authority for any documented delay. Chain of custody. The record documenting the location and person in control of evidence from the time of its collection to final disposition. So you're like, yeah, where's the photos of the taillight, Proctor? Crime Scene Response Unit, CSRU, is a unit comprised of forensic scientists available to respond to crime scenes. Services rendered shall be documented. Services include, but are not limited to, documentation, collection, and preservation of biological DNA evidence, including blood, semen, saliva. So I'm assuming not in red cups, right? Red Solo cups that weren't even enclosed, right? Like, I don't even think they put like plastic wrap over them. It was just open air, used too. Like, not even brand new, recently bought from 7-Eleven or Stop and Shop, right? You get the used Solo cups that Tom Kelleher was using for God knows what. I guess playing beer pong with himself. I don't know, because he wasn't invited to Brian Albert's house for that party. I don't know. Not for nothing, if I were him, I'd be like, yo, not only am I covering for your backside, but I wasn't even invited to the party. Like, what gives, bro? Here's my used Solo cup. So, yeah, I mean, it would have been nice to bring that up. Have a professional walk through that. I mean, and then have Hank Breenan cross-examine him, right? Or call another witness. Call one of, I don't know, Chip's superiors back. Tully, one of the many guys who was under internal affairs investigation. So these are some of the juror questions. A lot of people were wondering, okay, well, you know, if they can't call an expert to talk about the shoddy investigation, then maybe they need to go back and amend the juror questions, right? So they do have quite a handful of questions that pertain to biases regarding law enforcement, right? So number 7, if the testimony were in conflict, would you tend to believe the testimony of a police officer more than any other witness simply because the witness is a police officer? I think that's a really good question, right? Conversely, 8, would you tend to disbelieve a police officer simply because the witness is a police officer? Especially after learning about this case. I would be a horrible juror for this case. Do you believe law enforcement officers are generally fair and accurate in their investigations? 10, do you have any strong beliefs, or have you been exposed to any strong beliefs from friends, relatives about law enforcement officers, prosecutors, or the government? It goes on and on and on, right? 11, have you ever been involved in a group, community, or individual activity showing support for law enforcement in or outside your own community? Now, I don't know how many of these are similar to the first initial jury questions from the first trial. I know a lot of you probably know better than me, but I think this is really good, like really digging deep into, okay, like, do you have any connections to law enforcement? I think this will help kind of weed out folks who might be potentially biased. And that, you know, in a way, that is the good thing about doing this again. I mean, as, you know, crappy as it is that we're here and we're doing the same exact thing all over again, the same song and dance, at least we have data. Now we have data. Now we have more information. We can re-strategize. We can watch back, optimize what we, you know, maybe did wrong last time, ask better questions, not only to the witnesses, but also to the jurors during this portion, because I feel like this is, you know, even though I've never served on a jury myself, I imagine this is just as important as how well your opening and closings are, how well your cross-examinations are, how strong your case is in general. Is who are you deciding? Who are you choosing as the finders of fact in all of this? Have you ever been involved in a group, community, or individual activity that was critical of the police or law enforcement in or outside of your own community? have you or someone else to you ever had education, training, or work experience in any of the following fields? Now, this is interesting too, because last time we did have somebody who was in law enforcement who served as a foreperson. But knowing that now, would you want somebody who is on law enforcement or has some training or education? I don't know. It could go one or two ways, because it could be helpful in terms of helping the other jurors understand the proper procedures and protocols that one is supposed to follow, right, in the deliberation room. So it could work in favor of the defense. It also might work against the defense. So it is interesting. I wanted to see too. Oh yeah, so this is about operating a motor vehicle under the influence. So yeah, I mean, I'll share this too if you guys want. Those are the jury questions. So this was actually published earlier by Ted Daniel. Not really sure how I'm feeling about Teddy boy these days, but I thought this was actually kind of interesting, because I feel like we did hear, but there are law students who are assisting in Karen Read's defense of working pro bono. A lot of them were clamoring after the mistrial was declared. And I mean, what a case to be working on. The amount of experience and knowledge you would gain, and like even just getting close to Alan Jackson, Bobby Alessi, David Guinness. This is worth the amount of student debt these folks have probably incurred from pursuing a law degree from Harvard or Northeastern. So, I mean, this is crazy. So 9 law students from Boston area schools are volunteering for Karen Read's defense team, including 5 from Boston College, 3 from Harvard, and 1 from Northeastern. None of them named Elle Woods, just saying. Though I think Elle Woods would be able to single-handedly acquit Karen Read, but that's just my opinion. The students will serve as law clerks, assisting with case law research, document preparation, and courtroom analysis. And it shows. I mean, you don't see anybody who's clamoring to work with the Commonwealth on this. In fact, if you're even working, even if you're a paid employee of the Norfolk County DA's office, you couldn't pay them enough money in the world to take on this case and prosecute. That's why they had to go out of their way to hire Hank Breenan to come and do the job. And you know what? Interestingly enough, Turtle Boy just dropped an article about our boy Hank Breenan, which I will also link in my description box as well too. Read told 25 Investigates reporter Ted Daniel that her team interviewed more than 50 candidates in the fall after her mistrial. Some of the clerks have been seated with her family during pretrial hearings, so maybe those are some of the unfamiliar faces that we've been seeing in the courtroom. They're all working pro bono for my defense, Reed said in a statement. 8 of the clerks are in their 3rd and final year of law school and are expected to take the bar exam after graduation. I mean, if they don't pass that with flying colors, like after working on this, I don't know what would help them. So yeah, I mean, that's pretty cool. Like, you know, Karen Read's got a lot of support, but that doesn't mean that she couldn't stand to use even more. That being said, if you enjoyed today's content, make sure you hit that subscribe button. Make sure you hit that notification bell so you do not miss the next update from me, and make sure you hit that like button, because that tells the YouTube algorithm that this is newsworthy news. And it is. I mean, this is going to be quite literally the trial of the century, and now more than ever. I mean, this has garnered so much more attention than it did even before the first trial, which still had a lot of media coverage. It is going to be bananas now. But if you want to make a donation to the Karen Read Defense Fund, you can do so here. I include this in the description box of every single video I post about Karen Read, and we've contributed this month, the month of March, $80, 20% of the earnings that you fine folk have helped me generate by posting these videos and talking my gob off about things I'm passionate about. So thank you so much for tuning in and supporting this cause. Even if you can't, donate your own cash or your own funds right now, that's totally cool. Just share this link with everybody. Share the Karen Reed Defense Fund. Talk about it with your friends and family. Get them educated about this case, because you never know when this situation could happen to you or a family member. I mean, it does happen. In fact, this was just shared by Linda Kenny Baden from Justice Served TV earlier today from the Innocence Project, about how 73% of women exonerated in the last 3 decades were wrongfully convicted of crimes that never took place at all on the last day of Women's History Month, which I didn't even know it was. You can read more about it here. So, and I feel like that's extremely timely. She's got a really excellent podcast as well, too. They recently did a show on the Glarers podcast as well, so you can go and check that out. Give them a like, a subscribe, all that love and all that jazz. Now, that said, I do believe a crime was committed and the culpable parties are not being held accountable. But that's another opinion for another video. So with that being said, I'll see you guys in the next one.